Welcome to this MBL webinar on financial remedies and the role of conduct. For those of you who don't know me, I'm Sadie Glover and I'm a partner, mediator and head of family law at Blazer Mills. This webinar considers the role conduct plays in financial remedy proceedings and the court's approach to the principle. So courts are extremely reluctant to consider the issues that give rise to the breakdown of a marriage. Conduct is only taken into consideration if, in the opinion of the court, it would be inequitable to disregard it, and that's as per Section 25(2)(g) of the Matrimonial Causes Act. Conduct, especially non-financial conduct, is only relevant in a small number of cases, and practitioners are generally discouraged from arguing it. Although the requirement that the conduct must be gross and obvious was repealed back in 1984 as per Section 3 of the MFPA, in practice there is still a very high threshold indeed to overcome before conduct is likely to be relevant. In Setov and Kairova, Mr. Justice Peel gave some procedural guidance when pleading conduct. Effectively, the party alleging conduct must prove the fact relied on. It must meet the high threshold for conduct. There must also be a causal link between the conduct and the financial consequence. The court must then consider how the conduct and the consequences should impact on the ultimate award. Conduct must always be pleaded, so a party who seeks to rely on the conduct of the other has to raise it at the earliest opportunity and set out the allegations, stating how they meet that very high threshold and identifying their financial impact. The conduct allegations have to be pleaded in Section 4.4 of the Form E. The court should determine at the first appointment how to case manage the alleged conduct, which includes preventing the party who pleads it from relying on it if that exceptionality threshold is not met. Usually an exchange of short, focused narrative statements will suffice in this regard.